Policy Counsel at the NAACP Legal Defense and Educational Fund. I thank you for the opportunity to testify today on the urgent need for the complete repeal of 50A. Now, I did prepare a written testimony, but now, given that you guys have my testimony, I'm going to take this opportunity to respond to some of the comments we've heard earlier today. To be clear, 50A must be repealed, not replaced, not amended. The NYPD came earlier and spoke specifically about their ability and their willingness to make amendments to 50A. I think we've heard other panels speak about modifications to 50A. But the reality is anything short of repealing 50A completely will just land us back here in a few more years with different stories, different mothers speaking of different pains. There's been lots of discussion about the courts today. We know and we've all agreed that 50A was enacted with a very narrow purpose in mind. However, that purpose has been completely obliterated. The courts have viewed 50A so broadly that for the last 5 years, the last 5 annual reports, the Committee on Open Government has stated that there's been, quote, an alarming lack of public information about law enforcement agencies that these 50A rulings have engendered. And the committee's most recent report in December 2018 specifically noted that courts have viewed 50A so broadly as to withhold information from the public, even in cases where the police department themselves have acknowledged that officers' wrongdoing. The report concluded by noting a repeal of 50A is long overdue. I'll also note that even though the NYPD did stress that there's been times when they've been willing to reveal additional information, they've been stopped by the courts in the court's broad view of 50A. I'll also talk briefly about safety. There's lots of fear-mongering going around about the safety of officers. And I know you've heard this before, but it bears repeating. FOIL has adequate protections for the legitimate safety concerns of officers. FOIL has protections for every public employee that protects their personal information from being out, and then additional protections for law enforcement. Additionally, there's been statements about whether or not outside of FOIL there can be access to law enforcement's personal information given the internet. I'll remind you that major cities like Philadelphia, Los Angeles, Chicago, with major police departments, all have some sort of way for their police departments' personnel records and disciplinary records to be released to the public. And there's been no correlation, no empirical evidence that shows that making these records available to the public has resulted in more threats or more risk to officer safety. And I will note specifically that in Chicago, a group posted over 240,000 allegations of police misconduct publicly. These are allegations, not substantiated complaints, just mere allegations, with more than 22,000 police officers' disciplinary records, and there was no indication that this jeopardized officer safety. In fact, the statement that came after that specifically said, in the 3 years since we first made the limited release of police discretionary information public, nothing of that nature has been reported. I find it particularly disturbing that officers came before you today and spoke about hypothetical situations of a hypothetical person who may get their information, who may view an allegation, and may decide to find the officer online and attack their safety, and brought up the fact that they want to protect their children. When we have a very real situation here right now with mothers in this room who are saying their children were not protected. And we talked about saying officers want to be protected in their homes. We literally have examples right in front of us of officers coming to your home, the place where you're supposed to be the most protected, and violating the community trust and then being protected by 50A. And this is where I'll go a little bit back to my original testimony. I think it's important to note, as Lupe said, the previous cases that have come before the NYPD. Police officers in New York State have for decades over-policed, unconstitutionally targeted, and harassed people of color, particularly Black and Latinx communities. As Lupe talked about the Floyd case, I'll just quickly remind you that a federal court found that the NYPD engaged in a pattern and practice of racial profiling and unconstitutional stops under the Fourth Amendment and the 14th Amendment. Then in 2010, LDF served as co-counsel in a separate case, Davis versus City of New York, where we challenged the NYPD's practice of unlawfully stopping and arresting New York City Housing Authority residents and their guests for criminal trespassing. Residents and their guests for criminal trespassing. Again, those that were targeted were overwhelmingly Black and Latinx. And when that case settled in 2015, a federal court again required the NYPD's full participation in federal monitoring. That is the police department's current situation. In response to both of these rulings, the NYPD then decided to ramp up its gang enforcement practices under the guise of precision policing. But we've seen that the gang enforcement practices are the functional equivalent of stop and frisk. Currently, 99% of the people on the gang database are people of color, and 88% of the people on the gang database are Black and Latinx communities. I say all this to say the culture of constant racial profiling still permeates the NYPD. We cannot have this discussion about repealing 50A if we don't address that and take that fact seriously. Despite this, we've seen countless times that the NYPD is not able to police themselves. They have not been able to address the real racial profiling and racial discrimination practices that permeate their entire department. When you combine a department that has all of these past discrepancies, unconstitutional practices, and then you couple that with secrecy of 50A, it's a recipe for disaster. It is the exact same reason that Officer Pantaleo had numerous both substantiated and unsubstantiated complaints against him, that he had been sued 3 times for falsely arresting Black men, that he had multiple allegations of excessive force for people of color, and none of that was discovered or addressed until he killed Eric Garner. Examples like this and examples that we heard from the families today make it clear that a failure to repeal 50A is it's either a blatant denial of the facts or a complete disregard for the safety and security of New Yorkers. And I'll just conclude by saying this. Repealing 50A is urgent. We talked a lot about it being personal. This is a matter of life and death. Police, correction officers, and firefighters are public servants, sworn to protect and serve all New Yorkers. When they fail to measure up to this oath, the public deserves to know. And it's not just about the officers. When their departments and their supervisors fail to justly discipline them and get them out of the department, the public deserves to know. And as history has clearly shown, the police should not be able to police themselves. We're requesting the most basic allowance of transparency and accountability, the lowest level. For these reasons, I ask you to repeal 50A entirely.